Welcome back to this second episode of the Archipel Talks with José Ricardo. As anticipated in our previous episode, today we're going to talk with him about the scrutiny of arbitral awards by the ICC Court. I was wondering basically how the scrutiny is assigned to the court member. Is it random, or basically there is someone that is assigning the awards to each court member?
Yes.
So how it works basically?
Okay, so by the time that I left the ICC Court Secretariat, we were having 2 court sessions per week, fixed court sessions per week, usually on a Thursday, one in the morning, one in the afternoon. The morning would involve the teams, overseas teams in Asia. The afternoon would involve the overseas teams in the Americas, plus other teams in Paris. So you would have 2 court sessions every single Thursday, plus one plenary monthly session at the end of the month. So as you can imagine, we're talking about, uh, 9 court sessions a month, and those were the official fixed court sessions. So clearly, you need to organize those in advance. And there is someone in charge of organizing these court sessions, and that person will be contacting court members well in advance, and will start constituting those committees of the court, with the people that are available, with the people that indicate that they are available to do the work. So let's say the committees of February probably are already constituted, but in January you don't know which awards you will receive for scrutiny. So in that sense, the awards are assigned to the court session of the date in which the award is ready to be scrutinized. So in that sense, it's you can say it's randomly assigned to a court session. There are a few exceptions, though. One issue that we had to deal with while I was there was the increase in the number of awards that were not drafted in English or in French, which were the 2 official languages of the ICC until recently. So if you had and that was particular my case dealing with Latin America. Very often I had awards in Spanish or Portuguese. So back in the day, those awards had to be translated into English and or French for the award to scrutinize, for the court to scrutinize them. Which made little sense, given that you have court members from many countries, many of which would speak Spanish or Portuguese, right? So at some point, a decision was made not to translate those awards and to constitute special court sessions to deal with awards in particular languages. So in addition to those court sessions that I told you, like the 9 a month, you would start having more regularly special court sessions dealing with awards in a particular language. So those awards were not assigned randomly. They were assigned to a court session that was constituted particularly for that award or a group of awards that had to be done.
And when a court member is scrutinizing an award, he does so after the secretariat. So he gets the award with the comment already of the secretariat, or basically each one is doing the scrutiny in parallel, so that no one, the scrutiny of someone is not affected by comments of.
Well, the tradition was that the secretariat would send its report together with the award to the court, right? So the report of the secretariat was a basis for the scrutiny of the court. These days, the amount of work is incredible. At least when I left the ICC, and I understand that continues to be the case, very often that is done in parallel. As soon as you receive an award, you send it to the court members, and the secretariat will do its review in parallel together with the court.
When you were a counsel, how many awards did you read per month?
Well, I remember that it was about 60 or more awards per year. You do the math. That's quite a number of awards per month.
And then when you move to a position as managing counsel or deputy secretary general, I guess that you still have to read the same amount of award, plus you have to deal with the logistic that you were
Well,
describing.
we would split the awards with other members of management. Of course, the review that I would do at that stage was not a as thorough as the review that is done by the team members. So I would focus on the comments that have already been made by the team members, to make sure that those comments were appropriate, and I would focus on the substantive parts of the award, rather than on the formal parts of the award. So it was, let's say, a lighter review of the award, because otherwise, as you point out, it was just impossible to deal with
And when you
everything that
make
we have to deal with.
and I mean, your observation about the substance led me to ask you the next question. What is the scrutiny about? Is it getting into the basically the merit of the case? Obviously is not, but we also comments that are not intrusive, but I mean very detailed. And so I just wanted to understand what's the goal. I mean, we all know that the goal is to make sure that the award is valid.
Yes.
But not only, I understand. So can you tell me more about?
Look, for me, at least personally, that's how I saw the scrutiny while I was at the ICC. Was not only about enforceable awards. I believe that the enforceability threshold, these days, at least in the most, let's say, modern pro-arbitration jurisdictions, is very low. When people say that the court sometimes gets into the substance, it's not like the court says, the court evaluates the evidence and gets to a different conclusion about the case and tells the arbitrator, it's not, your conclusion is wrong. So it's not that. What the court will do is will try to fill in the gaps in the reasoning of the arbitral tribunal. Sometimes you know this because you've sat as you sit as arbitrator. Very often you're so much into your award, that for you certain aspects of the case are so obvious that perhaps you don't spend enough time explaining those issues. But those may not be, um, uh, may not be as obvious even to the end users. So the court will look the award with fresh eyes and will say, look, there may be some contradictions here, or this issue is not properly developed. And yes, sometimes the court will disagree with a legal finding because, of course, the people doing the scrutiny are lawyers. So they may have a different view as to the legal findings of the tribunal. And if that is the case, the court will explain why it believes that they have reached a different conclusion, and the ICC rules are very clear. At the end of the day, it's the arbitrator who decides. So if it is truly a substance issue and a difference of opinion, the arbitrator may explain it better, may improve the reasoning, but will probably not change his or her view as to the result.
What
But at
if
least the award will be of a better quality.
what if it is a substantive issue that could expose the award to a set aside for public policy issue?
Well, in those cases, it's a little bit more serious. Obviously, uh, it's a little bit more serious, and there will be probably more debate within the court, and the court will be more strict with the tribunal. And the court may decide not to approve the award until that issue is actually taken care of.
Okay. Can we make an example in that respect? I mean, I think we're thinking the same things, but I mean, sometimes maybe there is the need to reopen also taking of evidence in relation to certain issue.
Well, it may well be. I mean, I can give you an example that has sparked quite some debate between Paris and Geneva. As
Not surprised
as
about
you
that.
probably as not you're not surprised, as the Paris Geneva practitioners will often debate and will often have different views about certain things. But one issue that became very serious recently because of some decisions of Paris courts are, how far can the arbitrator go into, um, applying legal principles that may not have been addressed by the parties, right? And we've had a few, at least two or three awards that have been set aside in Paris because the tribunal has decided the case applying legal principles that were not addressed by the parties. And the view of the French courts is that the arbitrator can do that as long as those issues have been,
Of
as the
course.
parties have been given the opportunity to address those legal principles. And that is a clear example. If the seat of the arbitration is Paris, and we see that this issue was just not addressed by the parties, and the tribunal is just bringing it up in the award and basing a decision in that principle, then the court will tell the arbitrator, well,
And I think that even if the
you'll
seat
have
is
to
in
go back.
Switzerland, but
You'll
even if
have
the
to go
seat is in
back.
Switzerland and
Yeah.
they say that there is this, I mean, ambitious application of the principle of Jura novit curia, in any event, I think that the court will make that comment saying,
Correct.
yeah, I mean,
But the degree
yeah, obviously,
the degree will change because the court will know what the standard is in different jurisdictions.
okay.
So
And what
I
about
can
we?
tell you that we've seen some decisions from Brazil, for instance, whereby the Brazilian courts have said, the arbitrator knows the law and shall apply the law, and it doesn't matter if the parties argue the issue or not. Whereas in Paris courts, the Paris courts have been very clear. You
Okay.
can do it, but you have to put it to the parties first.
In light of the different jurisprudence between Paris and Geneva when it comes to corruption, I mean, obviously corruption is a public policy issue everywhere, but the degree of review of the assessment of the evidence of whether or not there
Correct.
was corruption, it's different. Does this mean that if the seat is in Paris, the scrutiny during the scrutiny, the arbitral tribunal can be invited to ask certain questions that are related to certain red flags, while in Geneva they would not push them to reopen the taking of evidence? Or, I mean,
Yeah, I mean, the degree of how far the court goes into demanding a change from the arbitrators will depend very much on
the
where
seat,
the seat is,
of
right? When the court knows that a particular seat will simply set aside that award, obviously the court will need to be stronger when it raises that issue. If the court knows that, you know, um, for purposes of the users and the satisfaction of the users is a good practice to do it, but that not doing it will not necessarily endanger the award, then the
of
court
course.
may take a different approach.
Thanks a lot for watching this second episode of the Archipel Talks with José Ricardo. During the third and last episode, we're going to talk with him about his experience at the ICC. If you liked this video or you want to know more about the next episode, please follow us on our LinkedIn page or subscribe to our YouTube channel. Talk to you soon.